When the Minnesota Supreme Court upheld 2 second-degree assault with a deadly weapon convictions against a man with a machete who was threatened by a man with a knife at a Minneapolis light rail station, the state's highest court also set a new precedent involving Minnesota's self-defense laws. In a split decision, the court wrote that long-standing Minnesota law says that a person needs to retreat when reasonably possible, even when facing bodily harm, and that security video contradicted the man with the machete's claim that it was not reasonably possible for him to do so. But according to Rob Dorr, the vice president of the Minnesota Gun Owners Caucus, the ruling means anyone who uses a deadly weapon in self-defense must look for a reasonable way to retreat before even showing a weapon.
Now, while this is relegated exclusively to Minnesota, this also tends to be the type of case that other very anti-self-defense legislators can try to glom onto. And frankly, not just legislators, this also can affect jurists as well. All right, so in this particular case, you have a defendant that has now been charged with what they call in Minnesota the crime of assault fear, which is an interesting turn of phrase. Now, to understand the fact, well, we'll start with the facts initially, and then we'll go through an analysis on how different states will deal with something like this. In this particular case, you have an individual, Mr. Blevins, who is standing on a train platform, getting ready, I guess, to board a train. And in this particular situation, he gets involved in some sort of confrontation with 3 other individuals. Now, this evidently is all captured on security cam footage, so there really isn't a dispute of facts. Now, during this altercation, which initially begins as being verbal, one of the 3, we'll call them victims, draws a knife and threatens Mr. Blevins. In fact, he goes so far as to say that he wants him to come into a little area where there are no video cameras so that he can slit his throat. Evidently, Mr. Blevins did not take him up on that invitation. Instead, he retrieves from, I guess, a bag or something, a machete. Because, after all, most of us tend to walk around with machetes. In any event, he uses this machete to engage in some form of threatening gestures, essentially letting these 3 individuals know that they have fundamentally failed in the victim selection process. The little knife that the one individual is using towards Mr. Blevins is no match for the machete that Mr. Blevins is now wielding. Well, ultimately, it causes the 3 to leave. Mr. Blevins is ultimately arrested for the crime of what is called in Minnesota assault fear. Now, candidly, this is not something that you see in very many other jurisdictions. Typically, you will see in other jurisdictions the simple crime of assault with a deadly weapon. It's essentially the same concept. If you point a gun, if you use a knife or a hammer or some other type of weapon in a particular manner that causes someone to have a reasonable fear that you are going to engage in what we sometimes refer to as an offensive touching, then that is usually prosecuted as a crime. Now, one of the defenses to that crime is that you were using this in lawful self-defense. That's by definition, right? If somebody's trying to kill you and you grab your concealed firearm and you use your concealed firearm, the individual has just, by definition, suffered an assault by a deadly weapon by you. Your affirmative defense to this charge is, I was absolutely justified in being able to do so. Now, many jurisdictions, in fact, most jurisdictions in the United States, have something called the true man doctrine. This actually is several centuries old. Essentially, it says that if you are out in public and you have a legal right, that is a threshold requirement, you have a legal right to be where you're at. You're not trespassing or engaged in some other form of criminal conduct, and someone threatens you, you have no duty to retreat, even if retreat is entirely reasonable. Now let's pause for a second. There's a difference between a legal duty to retreat and we'll call it a tactical benefit of retreating. All right, just because you may not necessarily have any legal obligation to retreat, it might actually be a really good idea based on the circumstances. Now, that notwithstanding, this true man doctrine sounds exactly what it sort of references. As a true man, you can stand your ground. And this is oftentimes heard when we talk about the context of a stand your ground jurisdiction. Now, in contradistinction to a true man doctrine or a true man jurisdiction, some jurisdictions, Minnesota being one of them, has what is referred to as a duty to retreat. As long as retreat is reasonable. That, by the way, is a triable issue of fact. But if retreat is reasonable, then prior to engaging in any form of force to repel an attack, you have to exhaust that retreat capability. Now, assuming that retreat is not reasonable, then you are authorized to use the requisite amount of force necessary to stop the threat. Now, okay, so with that in mind, there is usually a several layered analysis that takes place. The first question is whether or not the individual had a reasonable belief that there was an imminent likelihood of death or great bodily injury. That, again, is a triable issue of fact. If it is found that they did, in fact, have a reasonable belief, then the next level of analysis would be, was there the capacity for the individual to retreat? Assuming that there's not, then they could use deadly force or whatever force is required to stop the threat. On the other hand, if there was a reasonable belief that you could use deadly force, or that there was about to be an imposition of death or great bodily injury upon you by an assailant, and you did have a duty to retreat, and you had a reasonable opportunity to retreat, but you didn't retreat, then you have essentially foregone your affirmative defense of lawful self-defense. It acts essentially as a kill pill, so to speak. Now, Mr. Blevins, he was convicted, and he argued that the duty to retreat, this requirement does not appear in the Minnesota Penal Code. And in fact, it doesn't. It is what we call judge-made or common law. The Minnesota courts have held that there is this duty to retreat, even though there is no legislative enactment of this requirement. I guess Minnesota residents should just know that this is the way it is, that there is no penal code for them to consult. Now, in this particular context, though, the Supreme Court of Minnesota has expanded this doctrine. Remember, I said that before you use force, you have to have exhausted your duty to retreat, assuming you're in Minnesota. Well, now the Supreme Court has said not only are you prohibited from using force when you have a reasonable duty to retreat, you are prohibited from even threatening the use of force prior to that duty to retreat. This is massively problematic. Now, the court does try to somewhat narrowly tailor this. It says, well, only for this only really applies to the use of sort of a statutorily defined weapon. Now, okay, something that is known to be a weapon. Well, that itself is very problematic. And the dissent in this case points this out. They take great painstaking detail of explaining why a machete is a weapon, as opposed to being a tool used in Latin America primarily for clearing foliage. And who knows why Mr. Blevins was actually in possession of this thing? He may very well use this as a tool as part of his employment. The same thing would be consistent with a hammer or something like that. However, the way that we define weapons is usually on how they are actually used. It doesn't necessarily even have to be a deadly weapon, as the dissent points out. You might have a very small pocket knife, and that pocket knife is actually used primarily for non-use of force related activities, like opening letters or cutting off threads on a piece of clothing or something like that. And if you were to actually use this small pocket knife, it has a very low probability, and depending upon your skill set, I suppose, of being able to actually create a deadly force encounter. However, if you are using it to make someone think that they are going to suffer death or great bodily injury, then even though it may not necessarily have been identified by the legislature as a deadly weapon, it could be interpreted as a deadly weapon. The dissent further goes on to suggest a woman holding her car keys as she walks through a dark alley could be construed that she is in possession of a deadly weapon. They also would suggest that, chemical irritants like OC spray could be construed as being a weapon. Keep in mind, the legislature does not refer to a deadly weapon. It's talking about a weapon. So that in and of itself is somewhat problematic. In fact, arguably speaking, if you were to raise your fists and say, back away from me or I'm going to punch you, that could be construed as this statutory, penal code requirement of assault fear. You are putting a reasonable fear on someone else that they are about to have some level of violence inflicted upon them. And the Supreme Court of Minnesota has said you can only engage in this conduct if you have exhausted your duty to retreat. Now, in all jurisdictions throughout the entire United States, if you are in your home, if you're in your domicile, then by definition, you have retreated as far as you need to go. So if you're in your home and someone were to try to attack you, even though it would be entirely reasonable to flee from the living room to the kitchen, you're under no obligation to do so. Because you're in this unique location in Minnesota, because you're in this unique location in your home, you have by definition exhausted your duty to retreat. Now, philosophically, this makes absolutely no logical sense. After all, if you're on a train platform or you're in your living room, the fact of the matter that someone is trying to engage in an act that would require you to use some level of violence to be able to protect your own existence becomes completely irrelevant. Okay. There is also the question as to what reasonable is as to if retreat actually is a viable option. And this has been essentially eliminated from the trier of fact. They can't make that determination. If there was an option and they didn't take it, they are foreclosed from using the affirmative defense of, that they had to use their weapon to protect themselves from a violent act from occurring. Okay, guys, so I'm going to pause this video for just a couple of moments. I want to talk about a giveaway. USCCA, which sponsors this video, they're doing a giveaway right now. And it is really cool. You're going to want to get on it. It does end soon, so you're going to have to act fairly rapidly. You can read all about it in the description below this video. All right, with that, let's get back to the video. The remedy here, since this is a state Supreme Court, ruling, The remedy here would be for the Minnesota legislature to purposefully take up this and state emphatically within the penal code that there is no duty to retreat. This will absolutely obviate this really, really bad law, quite frankly, that's now come about as a result of this. So there is still a lot to unpack here. Keep in mind that everything that we're discussing right now is exclusive to Minnesota, okay? But as I said, there are several other, jurisdictions where they would love the idea of essentially preventing individuals from being able to exercise their inalienable right to continue to exist. This clearly is an abrogation of that right. This clearly puts people in a position where they are going to be second guessing themselves, where they're going to be extraordinarily concerned as to whether or not their actions, while justifiable in one jurisdiction and would allow them to continue to live, could wind up putting them in jail in Minnesota for upwards of 7 years. And that may very well be the idea, that it is designed to be a chilling effect. Okay, now one could argue, and there is definitely a political bias that exists on the Minnesota Supreme Court. One could argue that they truly believe that the state has a monopoly on violence, that no one, under any circumstances, is allowed to use any form of violence, even if it is to essentially protect their right to continue to exist. It also very, very well be a method to embolden criminals. Because after all, if a criminal is prepared to engage in some form of a criminal act against you and is prepared to use force in order to get you to comply in one way or the other, they've already essentially accepted the fact that they may go to jail if they are subsequently caught. It's the innocent victim of this criminal attack that is now put in the position of having to make a conscious decision. Do I have the ability to protect myself, or am I going to protect myself and end up going to prison for upwards of 7 years? As people go through that mental calculus, they may have run out of time, so to speak. These decisions are not made over the course of many hours. These decisions usually have to be made in the fraction of an instant. It's an incredibly problematic decision. All right, guys, as always, I know there's a lot to unpack here, and I definitely encourage you to read the full decision, especially if you do reside in Minnesota, because this does apply to you. So I would encourage you to read the opinion, and if you are a Minnesota resident, contact your legislator. Let them know how you feel. As always, if you'd like to email me, by all means do so at steven@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.